Victoria Jane is with us to unpack these recent advancements in different facial recognition technologies and the tensions that come from our privacy law.
So the Bunnings facial recognition case is one that has been widely discussed. What actually happened in that case and what did the regulators find?
Well, what happened in the Bunnings case is rather interesting. So between the time 2018 and 2022, Bunnings deployed facial recognition technology at about 60 of its stores throughout New South Wales and Victoria. Now, what they were doing was upon entry and throughout the store, using facial recognition technology, allegedly for the purposes of assessing whether or not any individuals entering the store were previously associated with any violent or physically aggressive types of instances. So the Privacy Commissioner found that Bunnings had in fact breached the Privacy Act by virtue of the fact that there wasn't active or valid consent given by those customers. There wasn't adequate notification given to customers entering the store, and there wasn't enough information and transparency, including in its privacy policy, informing customers as to what was being used and done with their biometric data. And that's key here because the biometric data is classified as sensitive information under the Privacy Act. It goes beyond merely the name and the address of an individual, but it goes to private features, the face, the composition, any of those features. And so that actually is classified as sensitive information under the Privacy Act.
So in February this year, the case was heard by the Administrative Review Tribunal. And we had a different discussion about what was reasonable, proportionate in that case. How did the tribunal differ from the Privacy Commissioner at first instance?
Yeah, it was an interesting turnabout because what the tribunal found was that whilst there wasn't valid consent, the conduct of Bunnings actually fell within the exception provided under Section 16A of the Privacy Act. And that's an exception available to entities where there is a genuine need and concern to undertake that kind of surveillance for a legitimate purpose intended to minimise or mitigate the risk to safety, life and health and safety generally. So that's what Bunnings relied upon, and the tribunal accepted that. So it found that whilst there hadn't been active valid consent, the conduct came within the exception of the Privacy Act. The other matters that the tribunal took into account were also the fact that Bunnings undertook a comprehensive risk assessment. And so it actually considered and properly analysed the measures available to Bunnings to mitigate these risks from, potentially violent or aggressive customers. It looked at alternative pathways and determined that the implementation of facial recognition technology was really the best and only available source of surveillance available to the stores. And having undergone that risk assessment, it really helped them come up in the tribunal and have the tribunal accept that conduct. But it wasn't without criticism because the tribunal agreed with the Commissioner that there were inadequacies and deficiencies in their processes around transparency and documenting, what was being done, collected and how that was used within its privacy policy. So whilst it, overturned effectively the decision by the Privacy Commissioner, it still demonstrated that there was room for improvement.
Absolutely. So it's clear that the stated reasons for employing these technologies will be paramount whenever we're faced with whether this is going to get into the realm of being too intrusive to breach our privacy laws. It's an interesting case to use to compare to another really widely publicised case of using very similar facial recognition technologies. And I'm talking about the recent Kmart decision, also from the Privacy Commissioner. What did the Commissioner find in the Kmart case and how did that differ between the ultimate decision in the Bunnings case?
Yeah, it's an interesting question because there were fundamental differences that resulted in the Kmart decision being very different to Bunnings. So in Kmart, there wasn't any evidence-based data or risk assessment policies demonstrating that the facial recognition surveillance deployed in Kmart stores was necessary. Okay, so that was a fundamental difference. Whilst Bunnings had undertaken a comprehensive risk assessment, Kmart didn't. Okay, and so there wasn't that demonstrated need for that technology, and they couldn't satisfy the decision makers that there was proportionality in terms of that facial recognition being deployed. Whereas conversely, in Bunnings, it was deemed to be proportionate to the need to mitigate those risks. So the differences were fundamental. And what it does signal to businesses is the need to obviously consider whether or not consent can be obtained, whether or not the conduct will fall within the exceptions provided under the Privacy Act. Businesses will need to demonstrate that it's undertaken a comprehensive risk assessment process, including considering proportionality of the surveillance technology being deployed, and then, of course, ensure that it's transparent with customers and it's documented the process, and so customers know how to find information about the use of that collected information, that sensitive information in particular, and how it goes about doing that. So big differences between Kmart and Bunnings.
So we can see that the regulator has shifted its approach to enforcement more broadly. What does this mean for businesses?
So the regulator is actually conducting compliance checks like it never has before. It's gone from responding to complaints to actually conducting sweeps across the industry to test compliance. So businesses really need to be across what they need to do when it comes to surveillance technologies and the Privacy Act and comply with it. So from January 2026, the Commissioner undertook a sweep of about 60 different businesses across a variety of sectors, and it has indicated that it's not going to stop there. So businesses need to be vigilant. They need to have evidence-based data around any steps and measures taken to introduce facial recognition technology and ensure that it's complied with its obligations to be transparent and provide consumers information that they're entitled to under the Privacy Act. Businesses should also be aware that the financial consequences here are not minor. A corporate entity that is found to have breached the Privacy Act obligations can be fined with up to $330,000 as a penalty for non-compliance, and with listed corporations, some significant sums as well, and it will be on a per offence basis. So the penalties can absolutely rack up. It's time to get ready.